Welcome to our third video of the journey to close, where we will walk you through what you can expect when purchasing a property in Florida. And in this video, what we're going to do is go over some of the most frequently asked questions that we get. And one of the first frequently asked questions we get is regarding the escrow deposits. So the escrow deposits are usually the earnest money deposits that are asked for in a contract to secure the contract. Sometimes there's one escrow deposit, sometimes there's two escrow deposits, but usually on the first page of the contract, you'll see something called the escrow agent. And the escrow agent is that person or company that will be holding the deposits in escrow throughout the transaction. The escrow agent could be the title company and the closing agent, or it may be the brokerage of the buyers. It may even be a third party attorney. So this is negotiated by contract. What's important to know about not just escrow deposits, but all money exchange in the transaction is the different payment types. Most escrow agents will accept a personal check or a money order or a cashier's check for the first deposit. But because of the way the contracts are written in Florida, where collected funds are required, it is very important that buyers are aware that usually starting in the second deposit, but definitely in the final cash to close deposit, the transfer of money must be in the form of a wire. It cannot be in the form of a check, and it should not be in the form of an ACH. And if this happens, this has the potential to really delay the transaction. Another frequently asked question is in regards to condo approvals. When there is a condominium association, most condominium associations require the buyers to be approved by the board of directors, and therefore there is a screening and there is an application. The application to the condo contains a lot of very important information, which the buyers really should read very, very carefully. There's a lot of information there as to what the buyer should expect in the condominium, what their roles and responsibilities are. And it even has information, for example, as to what dates the moving elevators are available if you want to move in. So all of this data is important for the client to read very closely, and the agent that represents the buyer should assist the client in going through these instructions. Now, it is crucially important to know that whoever the title holders of the new property will be, those are the ones that need to be approved on the condominium approval letter. The condominium approval letter gets recorded in the public record with the transfer of the property, so it must match. So if there's only one person on the contract, but there is going to be a husband and wife that will ultimately be on the warranty deed, both the husband and wife must apply to the condominium and get approved on the approval. If only the husband, let's say, is on the contract and only the husband gets approved, and by closing they want to add the wife, if the wife is not approved, we cannot close the transaction. This is also very common when a contract will be closed by a company, by an LLC or a corporation. If the LLC or the corporation will be the title holder, they will be the ones on the warranty deed when you close the property. That is the name that must appear on the condominium approval. The problem with this is that many times people apply in their individual name, even though they will be taking title in the name of an LLC, and the individual applying is the member of the LLC or the owner. But if the LLC is not mentioned in the condominium approval letter, you cannot close. So it's very important that we coordinate early. If the LLC will be taking title, you must inform the condominium and ask for the condominium approval in the name of the LLC. In terms of loans, there's a lot of confusion as to the loan documents, and there are two really important loan documents that are separate and different. One is called the note, which is essentially the IOU that states the amount of the loan, the terms of the loan, the interest rate, the length of the loan, and the payments of the principal and interest. And then you have the second document, which is the mortgage. The mortgage is a document where the people who have an interest in the property, the title holders, are giving up their right to their property to the bank for the bank to take the property from the title holders if the person who signed the IOU, who signed the note, does not comply with the payments. So let's say in a husband and wife situation, let's say only the wife takes out the loan and the wife is on the note. But because the husband has an interest in the property and they're going to live in that property as a homestead property, the bank will needs to ensure that both the husband and the wife sign the mortgage together, giving up their interest in the property if in this case the wife who is on the note does not pay the loan. This is a common source of confusion where married couples say, well, only one person is on the note. Why do we need to sign the mortgage? It's because under Florida law, both both parties, both spouses need to give up their interest to the bank for the bank to be able to provide the loan, even if only one of them is making the the commitment to pay the loan. Closing logistics. Where are we going to sign? What date and what time? This is a little bit hard to predict at the beginning because the title company is the one that calls for closing, not the lender. The transaction is ready to close when all the items on the to clear title are complied with. And most of those items that need to be complied with are items that the seller needs to comply with. And that is not usually in the control of the title company or of the buyer or of the lender. So even if a lender is ready to close, does not mean the transaction is ready to close. So there needs to be a lot of coordination, and the time and place of closing will be set between the borrower and the buyer and the title company or the closing agent after the bank has provided a loan package. And the reason for this is because many times loan packages are not ready until the day of closing. And so we cannot schedule a closing if we do not have the bank documents that need to be signed. We highly recommend that buyers do not make moving arrangements on the day of closing. And the reason for this is that many times there are delays the day of closing that are completely outside of the control of the buyer, the real estate agents, and the title companies, and even sometimes the lenders. So there's a lot of issues with closing that are sometimes out of our control. And many buyers, they want to schedule the move out date on the day they're projected to close. And our experience has been that this causes a lot of frustration and delays when things are out of our control. What are the things you need to bring? You always need to bring at least one form of photo identification. If you can bring two, that would be very, very helpful. Sometimes the buyers have the original condo approvals in their hands, so that's important that you bring. And we will usually get the buyers the cash to close before they come in to sign to the office. And that way, by the time they come, all the money is in the escrow account and we can proceed to signing. Now, another frequently asked question is about the role of the lender, right? Many times the lender is ready before the title company because many of the activities of the lender only depend on the borrower and the lender, while the activities of the title company depend on a lot of third parties like cities and municipalities and sellers' attorneys. And so it is important to understand that when the lender says they're ready, what the lender requires is a clear to close, which is when the bank's underwriter, the lender's underwriter says all the conditions for the loan have been met and we approve the loan. Now, when the clear to close is provided, that is not the same as when the bank provides the loan package. And the difference is that the loan package is what the borrowers need to sign to be able to get the loan. And so even if the bank is ready, if the loan package has not been produced to the title company, there's nothing for the borrowers to sign. This requires a lot of coordination and sometimes it's frustrating because different lenders have different terminology. But essentially, the title company will be able to schedule your closing once we know that there is a final loan package. And this frustration sometimes boils over into the cash to close. There are lenders who need time to be able to transfer the money, the final cash to close, to the title company, and they want to know how much it is. Most borrowers need to sign a CD at least 3 days before the closing, and there is an estimated amount there, but that is not necessarily the final amount. The final amount needs to be provided by the title company once the balancing process is done. So if there is good teamwork and good coordination, we will be able to get as much information as possible to the buyer as early as possible so that they can get their cash to close in time and stress free. And again, setting the closing date. The closing date is set by the title company once the lender has provided the loan package and not before. And this is why we don't recommend setting a move out date until we know not only that we have the clear to close, but that we have the loan package. And remember that many times there are mortgage brokers in between the lender and the borrower. And sometimes it's even out of the control of the mortgage broker when the bank will finally send the loan package. Let's talk about the role of the real estate agent. So the real estate agent is going to help with a lot of the contract terms, understanding, the leases, if there's post-closing occupancies and appraisal contingencies. And here we always invite the buyer or the seller and the real estate agent so that we can all talk and kind of get on the same page. The real estate agent will usually help refer an inspection company. The real estate agent will lead the walkthrough, which is the final inspection right before closing. If there are negotiations during the contract, the real estate agents are usually handling that, but we're always available to talk through any scenarios that you might find helpful. The real estate agents have to coordinate the keys and access. So some sellers will send their keys to the title company for closing, but usually the listing agent will coordinate with the buyer's agent. Once the transaction is closed and the money has been sent to the sellers, that is when you can expect the listing agent or the sellers to provide the keys. Sometimes they do it before, but it is up to the real estate agents to coordinate what we call the handoff, right? The final keys. So many times the buyers will come to the closing table and they'll be surprised that the keys are not there. And that's usually because the listing agent or the seller's attorney are holding the keys until the transfer of money is completed. So this is very important to set expectations. In terms of the role of the title company, we've recorded 2 other videos that explains to you what the title company does and what the stages of the process are. But essentially, the title company will act as the title agent to produce a title insurance policy based on the review of the history of the title, as well as the closing agent. So all the funds and all the legal documents that need to be exchanged get collected in escrow by the title company. And once all the terms and conditions are met, then they will disperse the funds to the seller and whoever else needs to get paid, like the seller's mortgage. Key information requests are very important. These requests are made in the first 48 hours of the transaction, and delays on getting this information can really impact the closing deadline. So we really suggest that things such as title vesting and marital status, and whether the buyers are going to be traveling during the transaction or they're not going to be present, these are the kinds of things we need to talk about early. Um, in terms of sellers, there's a lot of seller information that needs to be collected. Sometimes sellers get independent attorneys. Sometimes they work with a title company. So there's all sorts of information from the seller that is required to make sure that we can comply with the timeframes. And from the real estate agents, there's some really important information. They usually help us collect association contact information, definitely commission disbursement information. We like to pay the real estate agents always at the time of closing, but many times we don't have the right information, whether we're going to pay them with a check or with a wire, or whether we're paying their broker to a separate account. So these things we can talk about early and set expectations and hopefully have as smooth as possible of a transaction. Make sure that you're talking to the transaction coordinator from Folio that can help you understand some of these questions. And I invite you to see some of our videos and blogs that will go into more depth on this. We hope you have a really smooth and great experience during the transaction. Good luck.